Every employment is governed by an employment contract. The contract may not be written down though, so the second kind of severance pay after statutory severance pay in British Columbia is contractual notice, or the severance pay that is given in the employment contract. The employment contract could not provide anything less than what the Employment Standards Act would give to the employee. So if the employment contract says we can dismiss you on 2 weeks of notice, that would be an unlawful term in the contract, and the employer couldn't rely on it to terminate the employment. The employment contract could say, could provide more than the Employment Standards Act minimum, so it could offer 3 weeks of severance per year of notice to a maximum of 24 weeks. That would be lawful, and the employee would be entitled to that amount on the termination of their employment. Sometimes we see contracts that come in that say this employment is at will. At-will employment is not a concept that we have in Canada, and at-will employment is basically an American concept that allows the employer to terminate the employee without giving any severance pay at all. We don't do that here. That term is invalid, and the employee who has that term in their contract may as well not have a termination clause in their employment contract. Some contracts aren't written down. Employees who have no written contract are still entitled to severance pay, but it's determined by the common law, and that is the law that judges make when an employee sues for wrongful dismissal and gets a decision back. So lawyers will look to the case law to determine how much severance pay an employee is entitled to have where there's no written employment contract.